So, the concepts of law and equity were fundamental to the judicial system that developed in medieval England. And although their relevance has become much less important in the modern American legal system, there are still some vestiges of the distinction that remain. And so, it is helpful to understand the history and evolution of both concepts. So, to start, we need to return to medieval England in the year 1066, with the new royal dynasty establishing the Curia Regis, which is Latin for Court of the King. And the new King of England used the Curia Regis to administer justice throughout the kingdom. However, as it began to take on more and more cases, it eventually divided into two separate courts known as the Court of Common Pleas and the Court of the King's Bench. There was also a third court called the Court of Exchequer, which dealt with taxes and revenue matters, but we won't get into that. So, the basic jurisdictional divide between these two courts was that the King's Bench would hear cases that touched upon the king's interest. So, cases in which the king was interested. And the Court of Common Pleas, by contrast, would deal with cases which did not touch upon the interests of the king. That is, cases where the king was disinterested. Yet, even after this divide, the Court of the King's Bench retained appellate jurisdiction over the Court of Common Pleas. And it was also understood that if a litigant would not be able to find justice in the Court of Common Pleas, they might still be able to petition to the king directly to administer justice in an individual case. Unfortunately, the Court of Common Pleas ended up developing a very rigid set of procedural rules that foreclosed justice in many cases. And so the number of petitions directly to the king grew, and the king subsequently delegated this authority to a royal officer known as the Lord Chancellor, who subsequently established the Court of Chancery. And so while the Court of Common Pleas and the Court of the King's Bench were common law courts, the Court of the Chancery was established specifically to correct the inequities that arose in the law. And so it was known as a court of equity as opposed to a court of law. So the courts of law, that is the Court of Common Pleas and the Court of the King's Bench, administered the common law, and the Court of Chancery was established to correct inequities that arose in the law and was thus known as a court of equity. And so, in fulfilling its responsibility to correct inequities at law, the Court of Chancery ended up developing many procedural mechanisms that were not available in the common law courts. These included such procedures as discovery, class actions, and bankruptcies. At the same time, the Court of Chancery also developed special equitable remedies that were not available in the common law courts, with the quintessential remedy being the injunction. And so, to guide the Court of Chancery in exercising these these powers of equity, the court developed what are now known as equitable maxims. And so these equitable maxims can be cited today to help guide a court in exercising the traditional functions of the Court of Chancery. Unfortunately, as these three courts evolved their practices and procedures, the courts of law ended up gaining a reputation for being rigidly efficient and therefore disposing a great many cases on procedural technicalities, while the courts of equity gained a reputation for being so inefficient that most cases were not worth the time and expense that it would take to process through the Court of Chancery. So, when the United States established its court system, we very quickly merged the concepts of law and equity into a unified court system. And many of the procedures that were formerly available only in courts of equity would now be available in courts of law. However, a distinction was preserved with the subject of remedies. And so to this day, American courts generally recognize two different types of remedies. And these are the common law remedies and the equitable remedies. And so the quintessential common law remedy is money damages. So, for the most part, common law courts were only able to remedy injuries by awarding the prevailing party with money damages. And all that means is that the court issues a judgment that says that the defendant owes the plaintiff money. As you can imagine, there are many instances in which money damages are not an adequate remedy for the injury that's been suffered. So, for instance, if a person steals your dog, it's generally not going to be good enough for the person to simply pay you for the value of the dog. Instead, the remedy that you would want is for the person who stole your dog to return the dog to you. And in order to do that, you would not be wanting a common law remedy, you would be wanting an equitable remedy, and in particular, the quintessential equitable remedy of the injunction. And so the injunction is a court order against the losing party to do or to not do something. And if the person violates the injunction, then the court can hold that person in contempt and send them to jail. So the equitable remedy is much more powerful and versatile than the common law remedy. But the American courts have preserved the distinction by saying that you can only access the equitable remedy if you can show that there is no adequate remedy at law. In other words, in order to get the equitable remedy of an injunction, you have to show that monetary damages are not going to be adequate to remedy your injury. However, in keeping with the historical function of the courts of equity, even if there is no adequate remedy at law, a court may still, in its discretion, deny an equitable remedy on the grounds of public interest. And even beyond the public interest, the courts recognize various equitable defenses, which would generally not be available in suits at common law. So, for instance, one equitable defense, which is quite important, is the defense of unclean hands. And so, in the example of the dog thief, a person might be able to raise the defense of unclean hands if he simply stole the dog in retaliation for the other person stealing his dog. And in that case, the court might deny the injunction because the plaintiff has come to the court with unclean hands. That is to say, the plaintiff stole the defendant's dog before the defendant stole the plaintiff's dog. One final note that I wanted to make on the distinction between law and equity is the availability of a jury trial. And so historically, jury trials were procedural features of common law claims. And for claims in equity, they would be tried by a judge alone. So it would be a bench trial. And although equitable procedures are now generally available for suits at common law, in general, common law procedures are not available for claims in equity. And so if you are requesting a court to grant an equitable remedy, you should expect that the court alone is going to decide whether or not to grant that remedy. Whereas if you are requesting a common law remedy of money damages, that will typically be decided by a jury. And for whatever reason, most American jurisdictions preserve this distinction.